Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to another Webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. On today's webinar, Bob will be discussing essential estate planning documents for essential workers. Those of you working the hardest on the front lines have special concerns about how to best protect your family and your stuff. Bob will be addressing those concerns on today's webinar. Before I pass the torch to Bob, I'd like to cover a few housekeeping details. Quickly, a disclaimer, and Bob will cover more of this in just a moment, but today is going to be educational, interesting. You're definitely going to learn something new, but it's not legal advice. If you do have a specific question and are looking for advice on something that's unique to you, then I encourage you to reach out to us. Also, remember that today's webinar is recorded. Tomorrow you'll get a replay link and you'll be able to share that link with family and friends, and you can watch that at any time. You'll also be able to put questions in the chat box today. If you do have a question, I encourage you to just pop that right in the chat box, and we will have a space and time at the end of today's webinar to review those questions. If we run out of time, then we will get to your question after the webinar. Now, why should you listen to what the folks at Mannor Law Group have to say? So first, you should know that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. He's currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. My own personal favorite reason, Mannor Law Group has been honored by the readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Mannor.
Hi, folks. Okay, we're going to go ahead and get started here. And as Savannah said, see if we can make this a little easier. So Savannah said we've got a number of things to cover here. We're going to be focused on essential workers today. And so I don't mean to be too blunt about things, but one of the things that we're worried about right now, one of the things that we're thinking about right now is what happens if something bad happens. So that goes into two categories, right? And what I mean by two categories is we're all thinking about, being exposed to different things. If we're essential workers, there may be issues. We might be exposed to coronavirus. And what it comes down to is we really got a couple of different things that we need to be thinking about. And I don't mean to be flippant about it. I try to be direct without being too flippant about it, but it really comes down to what if we live and what if we die? And I point that out because sometimes people think about estate planning and having their ducks in a row or their legal documents in place, and really they're often thinking about, well, what happens if I die? And we all are kind of thinking about that a little bit now, right? We're all thinking about that from the standpoint of what would happen to my family, what would happen there. But as you know, if you've been paying attention to any of the things with regard to the essential workers that people are very concerned about right now is, well, what happens though if I am incapacitated? So what if I am in the hospital? What if I am on a respirator? What if I am, confined or restricted to being able to quarantined or mandatory quarantine or something like that? And so that's the what if I live conversation, because often in my presentations, and I do a lot of presentations, but often in my presentations, one of the things that we're talking about is, people come to their lawyer to talk about what happens when they die. And I think the more important question is, what happens if I don't die? And again, I'm not trying to be flippant about this. It's the thought process. And so the issue is, what if I live, but I'm incapacitated? What if I live, but I'm confined to the hospital? What if I live, but I'm mandatorily quarantined? And so there's going to be some things that we've got to talk about, and I've narrowed it down to a few different things. Critical documents, critical legal planning for your life. And so that's not what happens after you die. That's what happens if you got sick. What happens if you got exposed. That would be what happens if you had a mandatory quarantine, that you couldn't interact with others I know we're all in some form of quarantine, but what if it was sort of a mandatory quarantine where you really can't, are required to not interact with others? So there's the critical documents and there's the important ones. And there's a difference between the critical ones and the important ones. The important ones, I think, are important, and we'll talk about why maybe having a trust in place or something like that can sometimes be a good idea. But sometimes the important documents are things that we say, okay, yes, I want to do that, but will you get by without them? Yeah. What about the critical documents? And the critical documents are making sure that your loved ones that you trust to make decisions will be able to make those decisions without the interference of a court, without too much extra, hassle or difficulty. And so the critical ones are, if things go down, if things go badly, what do I make sure I have in place so that we don't have to run into court to make medical decisions, so that we don't have to run into court to make to pay my bills. And so those are the critical documents. And how do I make sure that my my spouse, my parent, my brother, my sister, my daughter, whoever it is that you're trusting to have access to information has access, that we're not going to be subject to some privacy regulation that's going to prevent them access. So those are the critical ones. And then there's the important ones that we really should be thinking about, but they're not quite as critical. So then the next conversation is, well, what happens if I die? And that is something that we sometimes are, a little bit more aware of when we think about talking to a lawyer. Is to, often people are saying, well, do I need a will? Well, probably. You probably need a will, and we'll talk about that in a minute. But what happens if you die? It really comes down to two things: what happens to my stuff, and what happens to the people that depend on you. And so what happens to my stuff? By stuff, what do I mean? I mean everything. I mean your bank account, obviously. I mean your house. I mean your car. I mean your jewelry. I mean your guns. I mean, but I also mean your life insurance. I mean your 401k. I mean your pension. I mean your, the investment account, that annuity, that CD. What happens to all that stuff? And it's a lot of stuff, and sometimes it doesn't have to be a lot of stuff, meaning that you have a lot of money, but it might be a lot of different things like possessions and different types of accounts. And most people are surprised when we start breaking this down for them, how many accounts they actually have. And a lot of people have a lot more accounts than they would otherwise think that they have. So that's the outline for today. And we're going to get into all of these things. And then we're going to kind of wrap things up by talking about the difference between legal planning and legal documents. You noticed in my outline, I didn't say critical legal documents you need for your life or important legal documents you need for your life. I said legal planning, and there is a difference, and it's a big difference. And so hopefully you're gonna see, as we're getting into some of the nuances of some of this stuff, that there's not just a one-size-fit-all document. I sometimes compare the legal profession with the medical profession to the extent that, I don't think anybody would go to their doctor and just say, well, I'm a 50-year-old man, and I have something wrong with me, or I'm worried there's going to be something wrong with me, so just prescribe me a medication. Just a medication. And that's kind of what we're doing when we're saying, oh, I'm just going to download a power of attorney form or things like that, or I'm going to write my own will or things like that. It is so not specific to your circumstances and your needs, and there is a lot of nuance here. There is a lot of things that we got to think about from the standpoint of your individual family and your individual assets, and how is it going to be managed for taxes, and how is it going to be managed, and how what is it from a practical standpoint. I always talk about difference between law school planning and real life. And in law school, we can talk about the ins and outs and the specifics of a particular document. What I care about is how is it going to be used in real life? If you take that document to the bank, are they going to accept it? Is it going to work? Is it going to be easy or hard for the family to work with? And so I think it's, too much of people's planning, even lawyers often, when they're doing planning, they're doing it from a theoretical perspective rather than a practical perspective. We try to be very practical and say, okay, well, this is how this works in real life. You might have this document. It doesn't work if you don't have it aligned properly with everything. You might have a document and it might be drafted by a really talented attorney, but if it's not, it's situated for your circumstance, or if they don't accept it at the bank, or they don't accept it when we go to sell a house or something like that, what good is it? It might be perfect from a legal standpoint, from a legal technical standpoint, but how easy is it to use? How is it really in real life? So that's the difference between legal planning and legal documents. All right, so let's Savannah mentioned that we're going to do a disclaimer here, and the idea of the disclaimer, sorry, we'll go back to that. The idea of the disclaimer is we're going to talk about a lot of different things here, and these are all important, good legal information, but it's education. This is education. So I don't know what your particular circumstances are, and obviously you should not rely on generic information for anything. That's the same thing as, like I say, in comparison to the doctors seeing a advertisement on TV for a prescription and then taking that prescription without having any context of whether it's appropriate for you or not. So that's our disclaimer. So let's start off with what if you live. And so again, this is particularly important for essential workers right now. Boy, it's interesting on the essential workers. I feel like sometimes it's the ones that not only are you willingly facing exposure, but there's just sort of this expectation that you show up for work and things like that, and very, very appreciative of all of the work that everybody's doing. But we do want to make sure that we've got our things in place, our matters in place here. So if you're going to be exposed to something, or have the potential of being exposed, we want to at least make sure we got those critical documents in place. And so we're going to walk through each one of those. And so the critical legal planning that we need, and again, I say planning because in my view, it really should be something where we are making sure that it's suitable for what your needs are, that it's suitable, that it's specific to your circumstances. Do you have kids? Do you not have kids? Are your kids minors? Are they kids adults? It's not a one-size-fits-all kind of a thing. And the first and probably most critical is this patient advocate designation. In years past, and I think sometimes people still have this expectation, is that in the event that you're on life support or something like that, that they would just go to the family and the family would make those decisions. Well, if you're over 18, that's not necessarily true. Yes, parents could probably make that decision for somebody under 18, but what if you're over 18? And so if you're over 18, really now the hospitals and doctors are going to want something in writing. And in Michigan, what we have is where we appoint somebody to convey our wishes for us. And we give some guidelines for them, and we set out how much flexibility they have or what authority they have. But it's very important. And so in other states, they have something called a living will. And the living will basically just says, under these circumstances, I do not want this type of life support. Well, that's okay, but it's not allowed in Michigan. That's not the preferred way in Michigan. In Michigan, we actually have something similar to that, but then we appoint somebody else that we trust and care about and cares about us, that would be able to convey our wishes for us and give them that authority. And that's what we often call patient advocate designation. Sometimes we refer to that as a PAD, patient advocate designation. Often many lawyers title that as a healthcare power of attorney. Unfortunately, that gets people confused because healthcare power of attorney sounds very much like a durable power of attorney or a financial power of attorney, and they're different, and they are different documents. You have to have both. There's not one document that can do both things. And the reason why there's not one document is they have different standards as to when they can be used. So it's really important that you understand we need both of those documents, and both of those documents are critical documents. So for the healthcare one, I want to be very clear, you're not giving up anything by signing a patient advocate designation. You're not giving up the authority to make your own decisions by any means. In fact, this document, and the reason why it has to be a separate document, it does not take any legal effect until you are unable to make your own decisions. And it cannot take effect. It cannot take effect until you are unable to make your own decisions. There's no way you could draft a document where you're giving authority to somebody else to make those critical healthcare decisions for you, as long as you're competent and capable. That's not allowed. You always get to make your own decisions. Now you can get advice, of course you can get advice, but ultimately you are the final say as regarding your healthcare, as long as you're capable. So this document only takes effect, only has authority or power to it when two doctors determine that you're not able to make that decision. Now, they might say you're unable to because you're unconscious, you're in a coma, something like that, or it could be because you have an inability to understand what's going on. So we see this often with Alzheimer's or dementia or other, critical things, a stroke. Boy, the stroke is one of those things that sometimes, we talk to the family and we say, okay, well, does Dad understand what's going on? And they say, well, I think so. I think Dad understands what's going on, but how do we know that? If after a stroke, if we are unable to communicate, if we're not able to speak, then sometimes I wonder for stroke patients if they actually do have the ability to make these decisions, but it's just very difficult for them to communicate that well. So that's one of those things. We've got to have two doctors determine that the person's not capable before this document takes place. Real important document, and there's some ins and outs. I'll give you some examples of why it's not just a document, it's legal planning. One of the things that we're going to think about is, well, what if there's a disagreement among family members? All right, well, there's got to be a mechanism for resolving that disagreement among family members. What if your kids disagree with their spouse? What if the kids disagree with each other? Can anybody put a veto power on it? Can anybody stop it and take it into court, or just stop the process? Or can one person make the decision? Is it the whole family? These are all things that we decide within the document. We have to do that. What if there's a difference of opinion among doctors? What if one doctor says, I think we should do surgery, and the other one doctor says no? What authority does the family have to have the final say in that? And sometimes people think, well, of course the family has. No, not necessarily. We have to make sure that this is an advocacy. We call it a patient advocate designation, and we want to make sure that it's advocacy. It's not just consent to what the doctors are saying. It's not just consent, especially when the doctors are disagreeing. It's an advocate that you get to go and get a second opinion and things like that. So we gotta make sure that's gonna be specific to the individual and specific to the person, and it's not gonna be some form document that we do. The next one is, how much authority do we want to give the family? If you're appointing your spouse or appointing your daughter, do we want to have them have broad authority? Do we want to have some restrictions on that authority? Does it include the artificial delivery of food and water? What does it include? Do you want to have some provisions in there that recognizes your faith? So this is sometimes with some folks when they're dealing with this life and death decisions, this is a big issue for faith, and some folks want to have some acknowledgement of the sort of sanctity of life and the importance of life within the document, so that we're not being flippant about life and death and not taking it into context of eternal life, I guess. So that's important too. And then this is a kind of a strange one, why we need to designate it and have it be specific to your needs is, what if there's some mental health issues? And my mental health issues could sometimes be dementia. This is gonna sound bad, but sometimes I say stubbornness can be a mental health issue, and I'm joking about that only to the extent of stubbornness. You could imagine someone who is then has severe dementia or Alzheimer's or something like that, but they're unable to recognize that in themselves, and so they're being non-cooperative, or they're refusing to take their medicine because they think that we don't know what they're thinking. But the bottom line is, can ever the family overrule the person? And what's weird about it is, in Michigan, there's rules about this that says even if you've been declared incompetent, unless we've stated otherwise, you have the right to revoke that document. So there was a case that went all the way up to the Michigan Supreme Court on this, where the person was in the nursing home and they had different relatives fighting about it and trying to convince grandma to do it one way versus the other way, or leave the hospital and go home by herself, which was probably unsafe, or stay there. And so when they went to grandma and said, well, grandma, you signed this document that says that you appointed this person to make these decisions for you because the doctors have determined that you're not capable of making that stuff. She said, well, I want to tear up that document. I want to revoke that document. This case went all the way up to the Michigan Supreme Court. And the Supreme Court said, yeah, she has the right, even if she's been declared incompetent, she has the right to tear up that document and revoke that document. And now we have to end up going back into court and all of that type of stuff. So sometimes we want to have a provision in there that deals with that. What if we're incapacitated, but we don't recognize that in ourselves, or we're being incapacitated, we're just being really stubborn, which happens sometimes when we have dementia. And so sometimes even personalities change when we have dementia or Alzheimer's or things like that. And so it's one of those things that we really have to think about, and we can put provisions in there that says, okay, if this is ever the situation, this is how I want it handled. So as you can see, these aren't just form documents. You just put your name in and sign it. It's a bad idea just to do that. Now, sometimes, and we've even done this as the whole shutdown, crisis came about, we've actually have, done some form documents that we've sent out to people, and it was intended to be a stopgap measure. Okay, if we've got people on the front line, if we've got people that they're really worried and they just want to make sure they had something in place, we have handed out those documents that are just fill in the blank. It's not. It was intended and still is intended. And we'll still do that for you if it's crisis and it's critical. We'll get those documents out to you. We don't even charge for that, and we can help you even figure out how to sign them. But the bottom line is, it's no substitute for real legal planning. Documents are not a substitute for real legal planning. All right, so that's real important. Financial matters. Okay, so obviously, if you're confined to the hospital or whatever else, a lot of stuff we can do online, but if you became incapacitated, we need somebody to be able to access your finances. And sometimes people think, well, I don't need that because I'm married and my spouse would be able to do that. Not necessarily. Your spouse might have access to your joint account, but what about your retirement account? If you have an IRA, 401k, your spouse actually doesn't have access to that. They might be a beneficiary of that account, but they don't have access to that. So we need that power of attorney. Otherwise, we need a court order. We need to go into court just to get access to that IRA or 401k. What about selling the house? Okay, you say, well, that shouldn't be a problem. What about mortgaging the house? What if you wanted to downsize the house? So married couple, one of you is incapacitated. How many signatures do you need if we're going to mortgage that house? How many signatures are you going to need if we're going to sell that house or downsize or buy a new house or whatever? And the answer is, if you're incapacitated, you can't do it. We're going to either need a power of attorney or we're going to need a court order. And that's the bottom line. We have these things called extraordinary powers. And what are the extraordinary powers? First of all, most people don't have that language. The extraordinary powers is extra special language that we put in there. And that is to deal with protecting your assets and qualifying for some government benefits so that we don't lose everything. So if we end up in a nursing homes are extremely expensive, right? And so a lot of people are worried, well, am I going to lose everything if I go into a nursing home? It's possible. Now we can help prevent that. And one of the things we do to help prevent that is put some additional language in people's documents called extraordinary powers, where you're giving extra authority to your spouse, to your daughter, your son, your brother, sister, whoever it is that you trust and love, and that you trust that they would not take advantage of that authority, and we give them extra authority. Again, you're not going to get that in a form document. Okay, that's not the way this works. Finally, the HIPAA waiver. This is a form document, the HIPAA waiver. The problem with the form document, though, is a lot of times you've signed one of these HIPAA waivers. This is the healthcare privacy waiver. And so with the HIPAA waivers, you've gone to a doctor, you have this document, but it's only as it relates to that doctor, and it usually has an expiration date. So I'd like you to have a separate one. What is the HIPAA waiver? Who can have access to your medical information? Who can call up and get a status report? If you're over 18, who can talk to the doctor and ask questions? So sometimes we have parents and their kids turn 18 and they want to call the school and ask questions. They want the kids in the hospital, and they want to, call and ask questions. And they're supposed to say, no, we're not going to answer those questions because of this healthcare privacy law, the HIPAA law. And so if we have this HIPAA waiver, then it says these people, I trust these people not to make decisions for me. Often it's going to be more people than we have making decisions, but these people would be able to ask questions. They'd be able to be in the room with me, those types of things. So those are important, critical even. Important. Well, so we have. We're going to go through a couple of these different things, and I'll explain this a little bit more in a bit. But important legal documents. They're not quite as critical as the critical ones, but I still think that something to consider. Now, not everybody needs a revocable trust. I'm not going to suggest that everybody needs a revocable trust. What I am going to suggest is it's something to give some consideration to. And yes, it's a lifetime document. Okay, sometimes people think about a revocable trust versus a will. Should I have a will versus a trust, right? Well, that's an important question. Okay, but the issue with the trust is that it is a lifetime document too. It can help manage assets during incapacity. It's a heck of a lot easier to use than a power of attorney. And there's reasons why that. It's the way the accounts are titled and how we use beneficiary designations and things like that. But the bottom line is the revocable trust, the financial company has to basically accept that trust at the point that we're aligning the assets with the trust. And so when you're healthy or when you're capable and have capacity is when we've made those arrangements with your financial companies. And so then when you become incapacitated, they've already accepted the terms of that trust and accepted who you've appointed to be able to make decisions. And ease of use. Now, I was thinking about this as I was putting this presentation together, and I have kind of a funny little story, and but what it relates to is occasionally I'll have people that tell me that their parents had a trust, and oh, what a hassle it was, and they took the trust to the bank, and the bank wouldn't accept it, and they wouldn't, they gave them a hard time, and so the idea of a trust is to make it easier. The idea of a trust, and in real life, in practical real life, this isn't just law school versus practical. In practical real life, the trust should make things easier. But I'm going to use an analogy, and that is, if you had, I like to often use cars as analogies, and I have a funny story about a car situation, but you can imagine and you say, okay, well, I had this one car and it was a lemon. It was terrible. It was an awful vehicle. And so now I'm against all cars. And I think sometimes people do that when they say, okay, well, I had this experience with this trust and it was a really bad experience. And so all trusts are bad. And then be like saying, I had one lemon car and therefore I'm against cars altogether. And that's a real thing. The quick story I think is funny. This is family history that was told to me secondhand because I was too young to actually remember this. But when I was very young, we got a car. It was a station wagon. My parents got a car, and apparently it stalled out on the drive home. It was a brand new car, stalled out on the drive home, and then for the history of the lifetime of that car, you never knew if it was going to work or not. And so we started calling it the Hail Mary car. And for anybody that's Catholic, you might understand what that is. So my mom, anytime the car would stall out, my mom would say, okay, let's say a Hail Mary to see if, hopefully the car will start. And so we called it the Hail Mary car because it stalled out so often. We were saying Hail Marys all the time, hoping the car would start. And so if we now said, okay, because of that Hail Mary car, now all cars are bad, that's absurd. That was a bad car. That was a lemon. There was something wrong with it. There was something wrong. If you have a trust situation, it doesn't work out smoothly. The whole point of a trust is to make it easier on the family, make it so that we have a master plan over everything, comprehensive plan for everything, as opposed to a hodgepodge from this asset has this plan and this asset has this plan. We have one sort of master plan for things, and it's supposed to be easier to use. Okay. Also want to talk about planning for parents here, so we're going to have some slides on that here. So let's advance this here. Okay, so we're going to talk about what happens when you die. Okay, so in a second we're going to get a little bit more into the will versus the trust and all of that, but and planning for parents. So yeah, okay. So what happens to your stuff? No will versus a trust. Well, what's interesting about that first one is that no will and a will are very similar sometimes. Now, it's not always the case. Again, there's no fill in the blank round, everybody fits one size fits all, because sometimes I say having a will and not having a will is sometimes the same. Well, in certain cases it is, and here's why. The state of Michigan has basically written a will for you, okay? They call it intestate succession. So there's instructions to say, if you don't have a will, this is what's supposed to happen. Well, in some cases, it's exactly what you would have put in your will. And so if it's a married couple and they've got 3 kids and they never had a second marriage and all the kids are from the marriage, and the intestate succession may end up looking a heck of a lot like what you would have written in your will. Now, where it gets messy is where it's not all exactly that, well, maybe there's a second marriage, maybe it's his kids and her kids, maybe it's there's issues with regard to different assets or things like that. But the bottom line is the state of Michigan has written a will for you. So we're going to talk about wills and how those work. We're going to talk about trust. A trust is basically just a contract that you write with your family. And since you have that contract, then we don't need to go through this will process, and it's just a more comprehensive plan. I'm going to talk about taxes, and there's a distinction, and hopefully I'll make this clear to you what the differences between estate taxes and income taxes, and then planning for heirs and children. What happens to people who depend on you, dealing with young children, what about adults, and those with special needs. So let's talk about this from the standpoint of the will. So I like to call the will a funnel. It's a catch-all. It catches whatever needs to be caught. One of the things that's important to understand about the will is your will does not decide where everything goes. Your will only decides where assets that don't have another mechanism of transfer. So if a will has if an asset is joint with somebody else, it doesn't go through the will. If an asset has a beneficiary or transfer on death, payable on death, it doesn't go through the will. If an asset is in a trust or part of the trust, it doesn't go through the will. Only thing that goes through the will are those things that don't have another mechanism. So why I call it a funnel is it's a catch-all. It catches those things that need to be caught, funnels it down to where it's supposed to go, but it has to go through probate. And that's the thing that people don't like about the will, is it goes through probate. So I was looking at a will a while back, and they had in their will, it said, well, here's what's going to happen with the life insurance proceeds, and this is what's going to happen with my IRA. Well, then I looked at their life insurance and their IRA, and I said, well, who do you have listed as the beneficiary on the life insurance? And they said, who is the beneficiary? And who do you have beneficiaries on the IRA? And they said, who is the beneficiary? And so my point was, the will, they went through all of this to put it in the will what's going to happen with those things, and the will would not work. That will would not work because we have beneficiary designations. Beneficiary designations are going to supersede, or they'll make the decision rather than the will. People don't always understand that. They think the will is going to be the binding document. It's only binding for those things that don't have a different mechanism of transfer. So sometimes people say, okay, well then I'm just going to put my kids' names on everything. No, don't do that. Or I'm just going to use beneficiary designations on it. That's a little bit better, but it's still not great. And the idea is it's not a plan. You're basically saying, okay, well, I'm relying on this company and whatever rules this company has. So if people die in the wrong order and I list my 3 kids and one of my kids dies before me, what's going to happen to that from a beneficiary? I don't know. We'd have to read the small print. Some people say, well, I talked to my insurance I talked to my insurance agent, and they said this is what would happen. And my point is, I've had lots of people talk to their insurance agent, and the insurance agent in good faith tried to answer their question, but that's not binding. The insurance agent's answer is not binding. It's the small print that we have to look at to see what would happen in those situations. And so it's better than putting your kids' names on it. Don't put your kids' names on stuff. That's a really bad idea, to put kids' names on stuff. You're creating a whole bunch of liabilities for yourself if you do that. But the bottom line is, so a beneficiary designation is better, but it still has all kinds of what ifs. And so the idea is having a more comprehensive plan. If you're a parent, what do you need? So here's what we're talking about. So I'm kind of combining these two things together as far as what if you live versus what if you die. Parental power of attorney. So if you're going to be away, whether it's in quarantine or because you're on vacation. Hopefully in the future we'll get to go on vacation again someday. But if you're on vacation and you're leaving the kids behind, you're leaving them with your parents, your sister, whatever, it's often a good idea to give them a parental power of attorney, where we're saying, okay, for this set period of time, I'm appointing this person to be able to make medical and other decisions for my child, including use of the insurance and emergency medical decision making and things like that. That's a legal document authorized by law, and it's really important that we consider that. A lot of times people just write a note, right? They put a note and they say, well, here's our Blue Cross policy, and I want my mom to be able to use this Blue Cross policy for my child because I'm going to be in quarantine or I'm going to be on vacation or whatever. And the answer is, well, will that work? Maybe it'll work. But we know that the legal basis for that is there's this form called the parental power of attorney. And if you need that, we'll be happy to provide that to you. What if your kids are over 18? Well, here's the problem. Once they turn 18, you have no control. And so I often say, if you have kids over 18, you should think about having them have a power of attorney. Having a HIPAA waiver, because if they're over 18 and they go to the hospital, you're not even supposed to get notified because of the HIPAA law. And certainly you wouldn't be able to make decisions for them. We'd end up having to go to court. What if there's some financial issue and you want to be able to help them access their account or whatever because of some incapacity? Nothing. You got no power if the day they turn 18, you've got no authority unless they have those legal documents in place. So something to think about. Who would raise the kids? This is important. A lot of times people have this in their mind and they say, well, I've talked to my sister and she agreed. Okay, but does the judge agree? Because you haven't talked to the judge, the probate judge. And so just because you ask your sister, that's not legally binding. And I've seen so many times where people, they said, the sister comes forward and they said, well, I had agreed to do this. My sister, I said I would do that. But then you've got other family members, especially in a divorce situation or something like that. And you've got other family members that now start fighting about it. And now we're going to a judge to make that decision. And so you can put that, the way to make this legal is we put it in your will. We put it in your will. This is who would raise your children. Okay. And that's binding. Now they have to, they still have to not, if they can be proven that they're terrible people or whatever, they can be removed, of course. That could be in any case with any parent, right, or any guardian. But the bottom line is, in the only legally binding way to say, this is, if I'm gone, this is who I want to raise my children, is in a will. And so we need to put that guardianship language in the will. What if you're divorced? Well, yeah, is there going to be a presumption that the other parent is going to be the guardian? Yes, but you never know what the future brings, and you never know what's going to come up with that. So I still suggest if you want to have an influence over, if you're gone and you're divorced, you want to have an influence over who's going to raise those kids, I still say we put that in there, even though, yes, the court would probably put a priority over the other parent, but you don't know what's going to happen in the future. If they, something happened to them, or they had some legal issues they were dealing with, or went to jail, or whatever else. Who knows what's going to happen? But the bottom line is, I strongly suggest if you have kids under 18 that we have a will and that we have it clearly laid out in there who would raise the kids, and then backups. And we, just kind of nuance things. If you say it's your sister, okay, so sometimes people say, well, my sister and brother-in-law. Okay, well, really? Is it? I mean, maybe that is the answer. Absolutely, that's perfectly good answer. However, my next question for you, and this is why it's forms versus planning, is if your sister died, would you want your brother-in-law to raise the kids, or would at that point it be the other sister or your mom or whoever it is? And I don't know the answer to that, but I think it's worthy of a question to say, because a lot of times we say, well, it's going to be Susie and Charlie, my sister and her husband, but is that really what you want, or are you just doing that because there's a fill in the blank and you write that line in there? No, we've got to think that through. Is it just sister? Anyway, so that's something to think about. Who would manage your money? It doesn't have to be the same person that would manage the finances. So if you're gone, somebody could be raising the kids, somebody else could be managing the money for them. Sometimes that's a great idea to have it be separated, because if this person that's raising them also has complete control of the money, there's not really any checks and balances there. So something to think about. Okay, this is just a real quick thing. A lot of people are worried. They say, well, when I die, I don't want the government to take everything. I have good news and I've got bad news. The good news is if you live in Michigan, die in Michigan, a resident of Michigan, you're probably never going to pay an estate tax or a death tax. So that's really good news. The reason why is that under the federal law, you don't have to pay state taxes until you get up to about $12 million. So if you got more than $12 million, definitely come see us. We'll help you organize your estate. But if you have under $12 million, you don't have to worry about death taxes because Michigan doesn't have a death tax and the federal government death tax doesn't kick in until $12 million. Now that law will change and there's lots of things. But right now, if you die today, if it was under $12 million, you don't pay any death taxes or estate taxes. What I'm concerned about is income taxes. Why income taxes? Well, most of us have IRAs or 401ks. Now those IRAs or 401ks, the money went in there before taxes. So now we've got to make sure that we've got it set up properly. So when those taxes get paid, this is particularly important if you have children under 18. They just changed the law on this. It's called the Secure Act. It went into effect January 1st, 2020. And now we have all these different options and a lot more strategy that we've got to be doing with this if we've got IRAs and 401ks, especially if we have young children, especially if we have any special needs or disabled beneficiaries. There's different rules and different exemptions and things like that. So it's not just oh, well, I'll just list them as the beneficiary. So a lot of parents would say, okay, I'm listing my spouse as the beneficiary if you're married, and then I'm listing the kids. Well, if the kid is 16, what's going to happen if you die and you list them as the beneficiary on your 401k? And the answer is they're not going to get the money at 16, right? The court's going to have to appoint what's called a conservator to manage that money until when? The day their 18th birthday. And guess what? On their 18th birthday, they have complete reign over that IRA or that 401k. And so if they want to buy beer money for their friends, or if they want, one of the attorneys in the office, she always uses the example of boys going out and buying a bunch of fireworks, or they could use it for college. But if you want them to have complete control over at age 18 versus maybe having supervision, maybe saying, nope, we're going to have Aunt Susie make that decision about how that money is spent until you turn 25 or 21 or whatever. Doesn't mean that we can't spend it on college. It just means maybe we shouldn't count on somebody when they turn 18 and never really had any understanding of money or any life experience. Maybe they shouldn't be making that decision yet. So that's important. We talked about the trust, and so the idea of the trust is that we have to make sure that the trust is going to be a much more comprehensive rule book. Okay, so it's a book of instructions. The will basically incorporates all the state's rules. With the trust, we're going to have a lot more pages to the trust, and the idea of the trust is that we're going to have thought about, well, what if somebody dies? You can do that a little bit in the will, but it's much more comprehensive. We're able to incorporate all of the assets better. Primary purpose that people think about for the trust is probate avoidance, but one of the things that I think is most important from a practical standpoint is also managing it during your incapacity. If you're incapacitated, it's going to be so much easier to use that trust, as we talked about earlier, than it would be to use a power of attorney. Okay, because we've already cleared that trust with the bank, with the financial company, things like that. Okay. All right, so we've kind of gone through some of these things. I want to kind of focus in on what happens to people that depend on you. Well, we have this option for generational planning, and the idea behind this is we say, okay, those 401k, the IRA, we want to have it set up in such a way that we can minimize taxes on it. And that's, again, not that's something that requires a case by case. We're going to look at those situations. We want to have that flexibility built into your plan that, you know, let's say you have one child that is doing very, very well financially, and the other one that struggles more financially. Well, we want to have different plans for them. The problem with that is we can't do that now. We can't set out different plans for them now. We have to build in flexibility so that if, you know, we have a plan that says if you die tomorrow, here's what's going to happen. But we also have a plan that has flexibility into it that says, well, if you die in 30 years, we don't know which kid is doing well financially and which one is struggling. We don't know which one is in the higher tax bracket and which one's in the lower tax bracket. So we want to build in flexibility to that plan to make sure that that we get the most money to the kids and the least money to the government. Okay. And so the bottom line here, oops, let's go back a little bit. Also, I guess we didn't talk about this yet, the planning for those with special needs. So sometimes if you have a child who's special needs or on disability, if it's SSI, there's different types of disability, but if it's SSI, meaning that there's restrictions on what assets they can own and how much they can have and things like that, we got to make sure that your planning incorporates that. So I'll have sometimes people say, well, I've been told to disinherit my child, and I'm just going to give everything to the other child and they'll make sure to take care of them. That's not ideal. I mean, we can do that if you want, but that's not ideal because what happens if that happens to, your other child dies or they get sick or whatever it is. And so you're able to set it up so that you can make sure to leave an inheritance to the child that's on disability or special needs. If you leave it to them outright or you use beneficiary designations, then we got a big problem. And the big problem is they're going to probably lose their medical benefits. They're going to lose their disability benefits. And so we got to make sure we leave it to them in the right format. And that's kind of goes back to this, where we see those umbrellas and we have those lifetime protector trusts. And so the idea is that we set it up for them. They're going to still get their inheritance, but they'll have access to that without losing their medical benefits, without losing their disability benefits. And this whole time we've been talking about sort of the difference between legal planning and legal documents. I do want to kind of circle back. Right now, if you are an essential worker, the really essential things that we're going to want to be talking about is making sure you have healthcare decision making in place, that we have financial decision making in place, that we have access and waiver of those privacy rules. And then if you're ready, and maybe you should be, that we should start thinking about, okay, well, do we want to have a plan that's going to make it easier? Do we want to have just the basics? And that's fine. Those essential ones are the critical ones are the basics. Or do we want to have it set up so that it's going to be a little easier for your family if you became incapacitated or die? Are we ready for that? Do we want to make sure we're structuring it to minimize taxes, structure it in such a way that's going to be most suitable for the family? And so this kind of wraps things up a little bit here. And so I'm going to see if Savannah has any questions, that if anybody's typed in any questions during the presentation. And then if there is, we'll answer those questions. If not, we'll wrap things up. One of the things I want to be clear on is that you certainly have, and what I would strongly hope that you'd consider, is making an appointment with us. Savannah's going to go through the options for you to do that. We're trying to make it as convenient as possible. Obviously, we're doing everything remotely, and we've have the ability to do everything remotely, including even signing of legal documents now. So she's going to talk to you about how to schedule that. You have an opportunity for a free, no-cost sort of interview with us, just kind of a 15-minute interview to see if it's something that you want an appointment, do not want an appointment. And at that 15 minutes, we get to interview you, you get to interview us, and we decide whether we want to move forward, and we'll talk about the process. So, and we try to make ourselves very available at this time to accommodate you, and you can even schedule your own 15-minute appointment. And then from there, of course, we're going to have more one-on-one appointments, but we just figured the 15 minutes sort of a low commitment to say, okay, I should at least explore more information. So I'm strongly recommending people consider scheduling one of those 15-minute dialogues, and then from there, after the 15 minutes, you can decide whether you want to schedule a one-on-one with remote one-on-one with me or one of the attorneys here, and we'll go from there. So I'm gonna see if Savannah, have you take over, and if there's any questions that have been written in, we'll address those. Otherwise, Savannah will give you other instructions.
Thanks, Bob. I don't see any questions in the chat now, so if you do have a question, now's the time to go ahead and pop that question in the chat box. If you think of a question at a later time, that's not a problem. We are available. Now, as Bob mentioned, I will be sending out an email. You actually may have already gotten the email, and if not, you'll have it any moment. And in that email, it'll give you 2 ways to contact our team. The first way is that if you would like to schedule that phone call interview with Katie, our client services director, Then there's a button. You'll just click the button in the email. It'll take you to her Calendly, where you'll be able to actually schedule that appointment at a day and time that's convenient for you. Katie will give you a call at that time, and then you'll be able to spend approximately 15 minutes just asking us questions. We'll ask you questions and just decide if we're the best firm for your needs. If for some reason we don't think we are, then we'll actually refer you to someone who can help. Now, if you're not sure yet that you need that interview, or if you're just not ready for that step, maybe you just have a question, or there's something you want to know, or a little bit more clarification. If you're a professional, maybe there's a client that has an issue that you wonder if we can help with. Anything like that. Also in the email, you'll have a separate button where you'll just click, and it'll take you to the Contact Us option on our website. You'll just leave your contact information and your question, and someone from our team will reach out to you within 24 business hours. So again, that email should already be in your inbox. Take a look, and be sure to forward it to anyone who you think could also use the help. Also tomorrow, I'll be sending the replay of today's webinar. That'll come to your email inbox. You'll be able to share that with friends and family as well. Thanks so much for attending today's webinar. We're happy you could make it, and we really do hope that it was helpful. Take care.